Please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the State of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBoos, with Jared Regier for the state, Mr. DeBoos in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBoos led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBoos, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the State of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me you apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible. If it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
One moment, Your Honor. Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issuable trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay.
And Your Honor, I would note that pursuant to the information filed with the court in August, this case does appear to include 3 counts, 2 Class Bs, and an unclassified non-person misdemeanor. While it would appear that in this particular instance, subsection 2, pursuant to KSA 216602, quote, for purposes of sentencing, the following classes of misdemeanors and the punishment and the terms of confinement associated for each class are established. Class B, the sentence for which shall be a definite term of confinement in the county jail, which shall be fixed by the court and shall not exceed 6 months. So, given that my understanding is that neither a plea nor sentencing recommendations have been submitted to the court in this matter, it would appear that at least the issue raised by standby counsel is somewhat academic.
So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now, before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's
I
the thing,
object to the word
Mr.
use.
DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you, and do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by a attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest
All right,
for
well, we're not going on.
22-2401.
We're
Arrest
not going
by law
down that
enforcement
path right
officer.
now, sir. We're not going down that path right now. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that?
No objections. Let me write those dates down. You said September what?
The pretrial is September 30th, 2024 at 9 a.m. And the jury trial starts at 9 a.m. October 2nd and 3rd.
Both of those dates?
Both of those dates.
Okay. I would like to point out that the bond and bail I made on this arrest is an unlawful bond, considering that the arrest was unlawful itself.
Looks like Judge Crum set your bond on August 18th, 2023 at $2,500 cash or surety, and that will be maintained so long as, sir, you appear at every date and time you're required. Anything else, Mr. Regier, we need to take up on this matter?
Your Honor, if the court is granting the defendant's request for continuance, I would respectfully have it noted for the record that this case at the next hearing will be over a year in age, as I understand it. So the state is not in favor of this continuance. So I would respectfully have that noted. Additionally, my understanding is that a motion in limine was filed by my office. And if the court is saying this matter for both pretrial and jury trial, I would respectfully reserve my rights pursuant to the state and have the motion in limine be addressed at the pretrial hearing.
That the objection of the
Service, I sent an email back to counsel, and I did provide Mr. DeBus's address that I had seen in the court system that they can directly mail that to, and I would just ask that that be mailed to Mr. DeBus for service.
And Your Honor, I am showing in my file an affidavit of service by first-class mail, and which would appear to include a mailing date of at the end of last week.
All right. Very well then. And if there's nothing further, did you get that, Mr. DeBoos? Did you get the copy of the motion he's in reference to?
To what mailing address did you send it to, Mr. Revere?
Well, just tell me if you got it or not, sir. Did you?
No,
get
I did not.
Okay. All right.
And Your Honor, one last thing. I did email to court and counsel the copy of the case law about constitutional right to a jury trial.
Thank you, Mr. Patterson. I appreciate that. And Mr. Regier, he wants to know what you sent that to.
I'm afraid I do not understand the court's inquiry.
He wanted to know what the defendant asked, what address you mailed the motion to.
Your Honor, the affidavit service I have in the file appears to be at an Andover, Kansas address.
Okay, are you still in Andover, sir?
I'm in Wichita.
All right, well, you have to keep the court informed of your address or you're going to maybe miss more important documents. So can you send your current address to Mr. Patterson and Mr. Regier in the chat here without having to say it live over the internet?
I'm not for sure the address is going
I'm sending in the mailing address now.
Okay.
And Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas. Okay, so that takes care of Mr. DeBoose's case. You are excused, sir.